All right, so this week we'll do employment law, and then we're going to do employment law. We're going to do it for 2 weeks. But next week I will be gone. So next week I want y'all to do your professional development assignment. I don't have very much turned in, so that's making me nervous. I did figure out about the interviews. You need to schedule those directly with the Career Center. And you can do it on Handshake, or you can just call them, or you could just show up over there. I mean, you can't do your interview when you show up, but you could show up to make an appointment. And the feedback I'm getting is that they do a really good job, that they have a ton of appointments, and that they're available. Does anybody have any experience with, has anybody gone to do their stuff with the Career Center? Is that working? You did yours with the online provider. Oh, you did yours there too.
Yeah.
Okay.
Set up an appointment and did the interview right then.
Okay. Who? Just show of hands. Who's done their interview? Class. Come on. All right. So I'm giving you next week to do that. That's okay. I would have waited till the last minute too, but as an instructor, y'all making me nervous. All right. Who's done their interview appointment with them? I mean, their resume appointment. Okay. I see a few more hands. All right. That's good. Don't be shy. All right. So next week, I really want y'all to hit that hard. So we'll do employment law this week. I'll probably just lecture this week, and then week after next, we'll finish up employment law, but we'll do all our discussion and stuff. So I think employment law is a very useful area for us, kind of like contracts was. Anybody in here take any HR classes? Yeah, with some HR components. A lot of that's employment law. And I think that it is definitely something that you'll encounter. So I want to let's just start with sort of a broad overview of employment law. Quick show of hands. Who all has a job right now? Who's employed? All right. Do those of you who are employed, if you want to, if you will share with us where you're employed, but I'm not going to force you. All right. Are you full-time?
Yeah.
All right. Mercedes-Benz, what do you do for them?
I'm the assistant sales manager.
Okay. Assistant sales manager. That sounds pretty important. Alan? All right. What do you do for them? Okay. What does that consist of? Oh, yeah. Okay. Cool. Excellent. Who else? Gio, what you got? Okay. Leasing agent at the apartments. Ethan? All right. What do you do there? Golf course maintenance. All right. At the country club. Alexis, you got one?
I do capital burger line. I do like security systems. I'm a technician.
Okay. All right. Is that a full-time job? All right. How long have you been doing that?
This is my third year.
Okay. Anybody else? What do you do for them? Okay. IT technician for the waterworks. Anybody? I mean, you don't have to. This just helps discussion when I know where y'all work. Yes, ma'am. All right, you're at the Marriott downtown? And what kind of agent? Oh, front desk. Okay, all right. So you're checking people in and out and all that? You got some horror stories? A lot. Do people treat you, are people rude? People offer you drugs? That's a perk. What's wrong with that? I'm just kidding. I bet front desk people could really tell some stories. All right. Of those of you who are employed, do any of you have an employment contract? You do, Gio? All right. And who else does? You've got a contract? Is it for a certain time period? Like, are you?
It was like when I first got hired on like a few years ago. It was kind of like just like the groundwork of like what's allowed, what's not allowed, and just be like kind of the culture there.
Okay. So when you get hired, there are a lot of things you have to sign off on saying that you have read the employee manual or you understand this is it. That is not the exact same thing as having an employment contract, although there are some lawsuits that make the argument that if you're going to sign all those things, that creates some sort of implied deal. The reason I ask that is that in this country, if you don't have an employment contract, you're considered to be an at-will employee. That means you can be fired for any reason, unless it's discriminatory. Yes, ma'am.
They actually make you sign a contract at American World, American Hospitality, that they can fire you for any reason and not tell you why.
So there's making you sign a contract, promising you, making you promise some things, but they can still fire you for no reason, as if you were an at-will employee. That's nice. So that my mind is going to what is the consideration on your part, I guess, or I guess the consideration is they're paying you. So at-will employees can be fired for any non-discriminatory reason. If I have one person that works with me, if she comes in tomorrow and says, I don't know, anything, it's cold outside, I could say, you're fired. I can do that. A better example would be she gets on my last nerve. I could say, you're fired, right? She's an at-will employee. If we have an employment contract, then the contract itself spells out the reasons why you can or can't be fired. Miss, tell me your name. Hold on. I'm mad at myself for not knowing it. Well, I can't find it. At the Marriott, your contract spells out you could be fired for any reason, but mostly they will say for cause or for violation of company policy, or if you've committed a crime, if you commit a crime, things like that. Your contracts will spell that out. I'd be curious to know, Gio and Xavier, if y'all see in your contracts, if you ever look at it, if it spells out what the reasons are that you can be fired for. Do you know what it says already?
Yeah, well, because I work at housing, so we have to get licensed to do certain things. So if you violate fair housing, you'll have to get fired for that.
Okay.
I believe if you have so many disciplinary actions or write-ups, you get fired for that.
Okay. So in other words, it sounds like you're protected by your contract from being fired for no reason.
But it also says if I am fired, I lose my house. I have to leave somewhere else.
You lose your housing. Yeah.
Yeah, because it's an apartment complex. I technically get a discount since I work and live there. So if I'm fired for any reason, they have the right.
That makes sense. Did you read the contract, every word of it, before you signed it? An honest man. I like that. He skimmed it. That's more than
I read
the important parts. All right. Like the pay.
Yeah.
Yeah. Right. Okay. All right. So employment at will is the default position in most states, that anybody can be fired for any reason as long as it's not against the law. There are not laws in any states that say that you can't be fired for being unlikable or for being a jerk or something like that. I mean, those are all legal, lawful reasons to take an employment action against somebody. Some states have wrongful discharge statutes that will give some protection to at-will workers, saying even if you don't have a contract, you can't be fired unless it's this reason or that reason. That varies so much by state that I'm not asking you to know the state by state law on wrongful discharge. Just know that some states have made exceptions to the at-will doctrine. And if you're an employer or you're in HR, you will need to look up or be familiar with or hire a good lawyer in the jurisdictions where you work, because those will impact you. So is a show of hands, but voluntary. Who is hourly and who is salaried? So do hourly first. We have some hourly folks. Anybody salaried? All right, so everybody is hourly. Do you know what the distinction between salaried and hourly is, other than that one person gets the obvious one? Ryan?
They can work you as much as they want.
There you go. Bingo. Tristan's nodding. Is that your experience too? Yeah, you've heard people talk, right? So if you're salaried, you don't get overtime. That's the biggest difference. But one of the most important things I want you to take away from this class is, as an employee or an employer, you need to make sure that you're classified correctly. All right, just because an employer says you're salaried, I don't owe you overtime, that does not mean you're not entitled to it. Here's why. The law spells out who can be exempt from overtime and who gets paid overtime. It's not an employer decision. It's the law draws that line. So if you're a person who is, every one of you in here is hourly, you need to make sure that you are indeed fitting the definition of an hourly employee so that you're not getting hosed out of some overtime pay. Typically, the line is that, or generally, it's that exempt non-overtime employees, salaried employees, have some managerial responsibility. They exercise some discretion in their job. The more discretion they exercise, the more managerial responsibility they have, the more likely it is that they are exempt from overtime. So there's not like a table you can look up and it'll say lawyer, exempt, salesman, not exempt. There's not like that. It depends on the actual job duties of that employee. And that's where a lot of people get in trouble is, maybe I hire somebody, maybe I run a manufacturing company and I hire some folks and I say that they're exempt from overtime, that they're salaried. And maybe they start out, the definition of their job duties does fit the definition for exempt. But maybe over time they transition to do other things, or their job just morphs into a different set of responsibilities. And maybe they're not exempt if we were to take a second look at it. So it's important to know, if you're an employee, that you're classified correctly. And it's important to know as an employer that you have all your employees classified right. Employers can get in trouble for back pay if they've misclassified somebody. So if all you guys who are hourly, no, y'all are fine because y'all all get overtime. If somebody is exempt from overtime, they're salaried, but they shouldn't have been, then you'll see lawsuits where they're seeking back pay for all the time they worked over and above the overtime limit. If you're an employer, there are benefits to having hourly employees. If they're not working, you're not paying them, as opposed to salaried employees. But there are you're exposing yourself to overtime pay. So, I mean, there's pluses and minuses on each one is what I'm saying. You need to make sure you're classified correctly, and you need to make sure all your people are classified correctly. Does anybody think they're misclassified? Everybody's pretty sure they're hourly. Who all, show of hands, who gets overtime? Y'all like overtime? Overtime's good, right? Time and a half. That is for hours worked in excess of, I think is it 80 over a 2-week period? So say that, Gary, say it again. Yours is 40 in a week, no matter what. Then there's sometimes it could be 80 in a 2-week period, but anything over 40 in a week is usually overtime. Is that y'all's experience? And overtime is, you get paid what? Time and a half. So if your hourly salary is $20, if your hourly rate is $20, you work overtime, you're going to get paid $30 an hour for everything over 40. It is tax. I don't know about you're the tax guy, so I was about to say, I don't know about the tax implications of that. I just know if I'm the employer, I'm stroking checks for more money, and if I'm the employee, I'm receiving more money. He said maybe not for much longer. Why do you say that?
Because the current administration is talking about not taxing overtime or tips. If
All right.
they actually do it, I don't believe it.
So we've heard. So there's a proposal out, or they floated the idea that they would not tax tips or overtime. What do y'all think about that? I think that'd be great. They do. Yeah, they do tax and bonuses. Has anybody ever had a bonus get taxed? When they tell you what your bonus is, you're like, yeah, and then you see it on your paycheck, you're like, where the hell did my bonus go? The tax rates on bonuses are bad. But anyway, I'll leave that to all you accountants in here. Minimum wage. Minimum wage has not changed last time I checked in many years. I think it's still, is it $7.50? So minimum wage is just that. It's the minimum. If a county or a state can increase the minimum wage if they want to, they just can't go below it. Like I think Seattle, I want to say, the minimum wage is like $15. Maybe New York has some higher minimum wage. California 16, thank you. So I don't know why the federal minimum wage hasn't changed since, is it 2006 or it's been a long time. It's been I can remember when it was 4 something. Yeah. So 7.25, I misspoke. 7.25 is the federal minimum wage. And a state could increase it if they wanted to. Speaking of, did y'all see last week where Georgia passed their tort reform package? I think we talked about this. I told y'all that the governor's main legislative initiative this year was to pass tort reform, which is like limiting the amount of damages juries can give in civil cases and personal injury and stuff like that. And I haven't gotten to kind of dig through it and see exactly what it is, but it was a pretty major overhaul. And it comes on the heels of that Columbus jury giving those plaintiffs, remember we talked about those $2 billion? No. Yeah. Was it $2 billion? $2 billion in punitive damages. And then another Georgia jury last week awarded another couple billion to somebody. Anyway, I want to talk about those before we finish out the semester, and we'll look at all that again. Maybe take a look at what the tort reform is doing to it. All right, so moving on to family and medical leave. I want to spend a little bit of time on this because this is important and also, I think, an interesting comparison point between the way we do it and the way other countries do it. So family and medical leave, it's accurately named. That is for employees to be able to take leave from work, be gone from work and your outline lists the reasons. To care for new children. So if you have a baby or if you adopted a child within the year, you can take family and medical leave. If you need to care for a seriously ill spouse, child, or parent, so close family members that maybe somebody's going through chemotherapy or they have been in a bad car accident and you need to take care of them, you can take family and medical leave for that. You can take family and medical leave if you yourself need to take time off because of a medical condition. And then there's one more that dealing with any non-medical emergencies arising out of a family member having military duty. So maybe somebody got, I was about to say deported. Deployed is the right word. Deployed, and that we need to make some arrangements for that. That might qualify as family and medical leave. So the law is pretty broad. It's a federal law, so that means it applies to all the states, and it applies to employers with 50 or more employees. So I have one employee. I am not subject to the Family and Medical Leave Act. My employee is not entitled to family and medical leave. You have to be at a place where you have 50 or more employees, and you have to have worked there for a year. So you can't just go work for somebody and then on your second day be like, I need some leave. Doesn't work that way. So it'll vest when you've been there a year. Who all works for a company that has 50 or more employees? Several of you. Who all works and who all's been there for a year? All right, y'all. Well, congratulations. Y'all are entitled to family and medical leave, which is a good thing, except for, what's that, Saheed?
My own situation is because I'm a part-time.
Oh, part-time doesn't get family and medical leave.
You should be able to. I used to work at Home Depot. After 6 months of being part-time, that's when you
They would let you do family and medical leave. All right, so the good news is, for you guys, you're entitled to family and medical leave. The bad news is that in America, family and medical leave is unpaid. So you can have the time off you need within limits, but you do not get paid. You do get to keep your health insurance while you're on medical leave. That's an important. And then if it's employer paid, they still have to do that. Might not pay you your salary or your hourly rate, but they will still pay your health insurance. So you're guaranteed not to lose that. The limit for family and medical leave in a 1-year period is 12 weeks. So it's not unlimited. So I know I've kind of gone back and forth, so let's go over that again. If you work for a company that has 50 or more employees and you're full-time, and you've been there a year, you can take up to 12 weeks of family and medical leave in any 1-year period that is unpaid. All right, the next part of this is that while you are out, I mentioned that your insurance can't be taken away. You still have access to that. When you get back, you're entitled to be restored to your original or comparable position. All right, that's an important qualification. It doesn't mean that your employer is required to keep your exact same job open. Now, if I tell you that you're entitled to either the same or a comparable position, all the litigation, the disagreement's going to be about what? Whether or not the position was comparable. I put you back in a different position. You think it was not comparable. I think it was comparable. We're going to have a disagreement about that. Okay. And again, it'll depend on the facts and circumstances of each case. If the job title's different, but the duties are the same, that feels comparable. If the job titles are different, the duties are the same, but the pay is different, that doesn't feel comparable. Right? So there are a lot of different variables that could go into it. Your duties, your pay, your hours, your working conditions, all things like that. You know, if they're going to pay me $10,000 less a year, that feels not comparable, but maybe my salary was $1 million and now I'm only making $10,000 less, that feels comparable. All right, if my salary is $30,000 and they want to pay me $10,000 less, that is not comparable. That's a 33% pay cut. In my first example, that was a very minor pay cut. So again, it would depend on the facts and circumstances. That is family and medical leave. That is a federal law. And you would need to meet one of those requirements in order to qualify for it. Has anybody had any experience with family and medical leave? Good. That means none of y'all needed it, which is a good thing. Occupational Safety and Health Act. Who has OSHA? Who deals with OSHA in their job? You did in the Army, right?
Well, not really, honestly. What was it?
It was
I think
applicable.
that's more in construction.
Okay.
And factories or something.
You used to, Kim? So how did OSHA apply to the CNA work? Oh, okay. Make sure you're wearing the correct PPE and all that stuff. What about Gio? Where do you work again? That's right. Y'all probably don't have too much OSHA stuff coming in. You probably do, don't you, Michael?
Only on like bigger stuff we have to do, like I think we like pre-wired houses. I haven't seen any, but we're doing a industrial facility, and they are always around there.
What about for your the vehicles, company vehicles and stuff? Are there OSHA restrictions around like securing equipment and I don't know. I'm wondering. I guarantee. So if you went to work in the morning and you said, "I'm going to make sure I'm complying with every OSHA regulation there is," you would never get any of your work done. There's not enough hours in the week for you to do that. There are probably so many that apply. I'm sure there's some that apply to this that I don't know what they are. Anybody have any hands-on experience with OSHA though? That any way that it has a major impact on your job?
Actually, years ago back in the Army, because I deal with majorly environmental stuff like when tanks, when you fill your tank and then you have like a oil spill,
Mm-hmm.
you need 6 feet.
If you had an oil spill in a tank, you had to dig a certain depth.
And one thing I understand, there was a time we got in trouble. I think it's $97,000 for one sport every day.
Oh, you got fined
Yeah, we got fined for
$97,000 a day by OSHA?
Yeah, by one sport.
Fining the Army? So that's the government fining themselves and then paying themselves? Yeah.
When the state comes, that's what you see everybody.
I don't know what the government does anymore. I'll be honest with you. We're about to find out, I think.
Especially people that work in the state, Georgia State, they're always on our head.
Yeah.
Like you have to be 6 feet. I said, well, I'm gonna take 6 feet for all spill.
6 feet for an oil spill?
Yeah, you gotta take. We're talking about drums of sand.
That seems excessive, but that's the kind of stuff. OSHA is not as much it depends on the facts and circumstances. They just make rules all the time, and you got to follow them. Yeah, it's with the depth of digging, that is.
With oil and dealing with the environment, yeah.
I'm sure the EPA would be in on that as well.
Because they walk hand in hand.
Yeah, they have a lot of overlap. Like cleaning up.
Yeah, you walk up together because normally when the federal government is coming, we don't have no officer, but when the state government,
Yeah.
simple one, they're like, okay, you're gonna be fine, or they tell you, they usually give you a warning, like, okay, we're gonna be back in the
So wait, so you'd rather have the state OSHA or the federal OSHA?
Federal one.
Okay, because they're more understanding.
Yeah, they understand because we go federal, but the state one.
So you think the federal OSHA cuts you more slack because you worked for a federal agency, and the state was more territorial about it. That's another good point. I'm glad you brought up. The Occupational Safety and Health Act is a federal law, but states have their own OSHA as well. So that's a whole nother layer of regulation that you'd have to comply with. They're all depends on what they pick to be for that day, but They can do they can do unannounced inspections and that kind of thing. Do y'all have to deal with that, Saeed? Did you know when they were coming?
But no, what happened is they won't even tell you. But the civilian in charge is like, okay, let's put it like this. Okay, the last time they came this time. So so we just walk through it. And when they come like that, they're not coming to you, they go to your big boss. They just take a picture, boom, boom, boom.
Yeah, they
Next
can.
morning you just get an email. Oh.
Oh, they were here. I know what happened yesterday. I gotcha.
Yeah, you know when the post commander just give your boss a call.
All right. What about workers' comp laws? Y'all know what workers' compensation works. Gio, you've had some experience with that. So, workers' compensation is a creature of state law. Each state would have their own set of workers' comp laws. But the idea is that if you're hurt on the job, they're not going to, you can get paid while you're out. And they're not going to worry about fault. You just get paid from a general fund that all employers contribute to. You get paid from the state, basically. But there's a trade-off to workers' comp. In exchange for you get paid, no matter if you were at fault or whatever happened, in exchange for that, you are giving up your right to sue your employer. So you can't double dip. You can't go get workers' comp if you get hurt on the job and it wasn't your fault. You can't get workers' comp and then also turn around and sue your employers, one or the other. The trade-off for you is if I go to workers' comp, they're not going to worry about if I did it, or we're not going to get into who was negligent. It's just, were you on the job? Did you get injured doing the job? That's why what?
They're willing to pay.
That's right. That's why the employers are willing to contribute to that fund because it saves them money overall. And honestly, if you're an employee and your only recourse every time you got hurt on the job was to sue, that would take a long time. And you might have medical bills, you might have to be feeding babies, you got expenses. And it might be easier just to be able to apply to work for workers' comp. I got hurt, I send in my paperwork, I get my workers' comp check next week. That feels, from a practical standpoint, easier and cheaper for everyone. But now, I mean, if something egregious happens and you've got a great lawsuit, then you would want to think twice about whether or not you wanted to go the workers' comp route and give away the potential of, a big jackpot, especially with these Georgia juries the way they've been doing lately. But that is how workers' comp works. Gio, did you get workers' comp?
Yeah.
How long were you out?
I was at work for a week.
Okay. And it just covered basically your weekly.
Any hours, any days and hours that I was scheduled to work, they did.
And how long did it take for you to apply and get approved?
Really the same day, honestly. Because when it happened, because it was a mechanical error from my coworker that injured my hand. So we had to go report it to my manager. My manager had to do something with OSHA, something. And then we had to call.
Sounds about right.
Because it was Home Depot. So Home Depot has their own nurses, hotline and stuff. Had to go through them. Then I had to go to the hospital, get something from them. And then by that point.
So you had to do a screening with Home Depot's own in-house medical people?
Yeah, because they don't have nurses in it. They have like a hotline that you call
Yeah.
to determine how injured are you.
Okay.
I imagine you don't call it if you're bleeding.
Which, I mean, I guess sometimes you're like, you need 911, right? I mean, but so what needs to happen? Okay. And then you were able to return after a week.
Yeah.
Okay.
I was able to return. I stayed in the manual labor.
So that worked out well for you, because if you had to sue your employer, that would have been impractical for you to do. Anybody else have experience with workers' comp? All right, that's a good example. income security, I don't want to get too deep into that. Everybody that's ever gotten a paycheck has looked at it and seen all the stuff that comes out for government programs that are purportedly to protect all different kinds of things, unemployment, Social Security, all those things that the public benefits we get, Medicare, Medicaid, that kind of thing. Your taxes are taken out, obviously, of your paycheck. Unemployment. I will mention something about unemployment. It's kind of like workers' comp in that if you get let go and it's not through any fault of your own, then you can apply for unemployment and you'll get paid whatever that state's rates and for the duration that state has. If you get fired and it's your fault, you can still try to apply for unemployment, but your employer might contest it. If they contest it, we'd have a hearing. They would have a hearing, and then the hearing officer would decide whether or not you're entitled to unemployment. It doesn't last forever. They extended it a bunch back when COVID hit.
Oh, yeah, they did. How long? That was like, I think, a year and a half.
Yeah, I mean, like you could just ride out. You could ride that for a while. Don't you? Do y'all feel like COVID was yesterday, and you realize it was like 5 years ago?
Yeah, 'cause I was sophomore in high school when that.
5 years ago, the world shut down this month in March. This is the 5-year anniversary of everything shutting down, and I feel like we still talk about it like we're still in it and like it was yesterday. You already a shut in? Sometimes I wish we could go back to being shut in. No, that was my first semester back teaching here after I'd been gone about 10 years. And I was excited. We started in January, and then come March, shut that back down, and we didn't come back for the whole year. So that was not as fun. All right, that's unemployment. COBRA, if you've ever heard of COBRA, the important thing to remember about COBRA is that when you lose your job, whether it's your fault or not, if you had insurance through your employer, you can keep it for a period of time after you're employed. I think it's 18 months, but you got to pay for it. And that protects and it keeps employees who are fired from being left out in the cold without health insurance. So it's a good protection, but it's not a great deal because, again, you're paying for it. This changes depending on the climate that we're in, but there was a time, and probably still the same, where it was cheaper to go to the marketplace and get a policy than it was to keep paying your COBRA premiums through your employer. But I guess it just depends on how good of benefits you had or not. If I got fired from CSU and I was in the middle of cancer treatment, I probably would want to keep my COBRA rather than going out and getting another policy. I mean, I don't know. All that stuff's confusing to me. But just know COBRA protects you from being left out in the cold without any access to your the health insurance that your employer provided you. Say that again.
Oh, I just read what the acronym was.
Oh, continuation of what is COBRA?
Consolidated Omnibus Budget Reconciliation Act.
Oh, I thought it. Oh, not even close. Yeah, it has nothing to do. That would not tell you anything about what it actually does it? Okay, so the default rule is employment at will. But whether you have an employment contract or you're an at-will employee, you can't be fired for a reason that violates the law. You can't be fired for an illegal reason. Mostly that's discrimination. So here's how the federal government has set up the mechanism for enforcing. Well, let me back out. most of the employment discrimination laws that we have in this country are federal laws. So they apply equally across all states. Each state can have their own employment discrimination laws that add to the protections under federal law. They can't take away from the protections under federal law. So you could have a stronger state anti-discrimination law than the federal law, but you couldn't have a weaker one. The federal law is the minimum. Employment discrimination or protection from being discriminated in employment is not just in one law. It's several federal laws. And we're going to talk about most of the major ones. I'm not so much interested that you know exactly which law protects which protected class. I'm more interested that you know what all the different protected classes are and how the mechanics of all this work. So just let me ask you guys, as far as discrimination, in order to be protected, you got to be a member of a protected class as established by law. What protected classes are you all familiar with? Somebody give me one. Ryan. Race is a protected class. Who else? I'm going to come back to you if I can't get somebody else. Miss Beaver, give me a protected class. Gender is a protected class. Good. And you cannot be fired for your gender. Yes. Age is a good one. Thank you. That is, and just by the way, do you know what the cutoff is for protection for that for age discrimination?
I want to say 60, somewhere in the 60s, 65.
40. So I'm protected. I cannot be fired for being old. All the rest of you can be fired for your age, but no. So yes, age is a protected class. So that's race, gender, age. There's a bunch more. Disability is a great one. I didn't say you couldn't get fired. I said you can't get fired because of your age. Disability is a really important one. The Americans with Disabilities Act covers that. Yep. Religion is a good one. Religion gets a little can get squirrely because the law doesn't specify. There's not a list of religions that are protected. It just has to be something that you sincerely held beliefs and some things like that. We're not getting too deep into that. Did you have one, Xavier? Religion is a good one. What else? What about being from a different country? Kind of. National origin. Yeah. National origin and race kind of go hand in hand. Religion, disability, age, gender. See if we... the anti-discrimination statute actually says the protected classes from that are race, color, national origin, religion, and gender.
If you look in the dictionary for race, it shows locations, cultures, colors, and culture. I already said culture.
Well, one aspect, and that's a good point. Well, one aspect I want you to appreciate about this is that it protects people who have been discriminated against if they are perceived as being a member of one of these classes. So even if you're not from a different country, if your employer fired you or demoted you or took some sort of adverse employment action against you because they thought you were from a different country or from this religion or that you were disabled. So being regarded as, even if you're not, being regarded as a member of a protected class does count. the federal mechanism for enforcing this is a little bit convoluted. And I'm curious to see, I'm watching closely what the Trump administration is doing with the EEOC, the Equal Employment Opportunity Commission, because they are the federal agency that's responsible for enforcement of employment discrimination laws. So this is how it works. If you if you think that you have been, let me not use you. If an employee thinks they've been discriminated against, and they want to file suit against their employer, they want to sue them for it, they first have to file a complaint with the EEOC. It's a prerequisite for going to court. We don't have a lot of statutes that set up prerequisites for going to court, but this is one of them. So if I get fired from CSU today, I think it's because of my age. I'm over 40. I want to sue for violation of the Age Discrimination Employment Act. I can't just go hire a lawyer and file my lawsuit. I first have to file a complaint with the EEOC. There are pros and cons of it, okay? The pros of it are that sometimes if a case is bad enough, the EEOC will sue your employer for you. It's pretty rare. But in some really bad cases, or when they might be able to maybe create a class action where there's a bunch of people who've been affected by the same employer in the same way, and it would be more efficient for them to be to do the suing, to be the plaintiff, than it would for all these individuals to do it by themselves, they might do that. It also screens out some cases that maybe don't have merit. So maybe I file a complaint with the EEOC and CSU responds to my complaint and shows that I showed up to class incapacitated. They got it on video and they had to call the police. I caused a big scene or whatever. That might discourage me from filing an actual lawsuit if the EEOC dismisses my complaint, right? Otherwise, we would just have a flood of employment discrimination lawsuits and the courts would have to sort it out. So it does operate as a sort of a screening out of some meritless complaints. If the EEOC finds that there was no cause, you can still sue. It doesn't take away your right to sue your employer. So if I filed a complaint and it got dismissed by the EEOC, and I just think I still believe deep in my heart that I was discriminated against, I can still sue. I'm going to have trouble finding a lawyer to represent me when the lawyer says, well, what happened at the EEOC? I got dismissed. No, thank you. I don't believe I want your case, right? So it does operate to screen out some cases. The cons of it, to me, are that a lot of times it's pointless. If I have a good case and I can sue no matter what they say, then why can't I just skip them, right? Why do I have to go through the EEOC process just to tell the court, okay, I can file my lawsuit now because I did comply with the EEOC. I did go through with their thing. If they find that I had a cause, it doesn't help my lawsuit any. The jury is still going to hear all the evidence and make their own decision based on what they hear, but based on what they think. So I think in a lot of cases, it just adds another level of bureaucracy and inefficiency to what we're doing. Interestingly enough, to me anyway, when I first worked, my first job out of law school was for a firm in Atlanta, and they put me in the employment law section. So I was working employment law litigation, and a lot of our clients were bigger companies. This was in Atlanta, and we represent people like Georgia Power and Ronstadt Staffing Agency, anyway, some bigger people. And they would get EEOC complaints filed against them daily because they had so many employees. This was just a commonplace thing. And they would get a notice from the EEOC, hey, this employee has filed a complaint against you. Here's the complaint. You get to read it. You get this many days to respond. And they would send it to us, and it would be our job to respond to the EEOC complaint. Well, you know, a lot of us and a lot of employers, a lot of our clients, their first instinct was when you get somebody files a complaint saying you did something wrong, your first instinct is to fight the hell out of that, right? I didn't do anything wrong, and I'm going to show you, here's the 100 pages of evidence I have, and this employee was terrible, and da 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 da. But I worked for a partner at the law firm who had a totally different philosophy. His philosophy was just don't say anything. If the person wants to sue us, they can sue us, and we'll handle it then. But we're not going to give the EEOC any information because it's none of their business. We're not going to give the employee any information on why we think they were fired justifiably because this isn't a trial. We're just going to ignore the EEOC. They can get their right to sue letter from the EEOC, and if they want to sue us, they can sue us. I mean, my experience with that was probably, I don't know that that's the right approach for every case. I think there were some cases where if an employee had done something so black and white, you know, that it was easy to show, I think it was easier to respond to the EEOC and maybe discourage that employee from pursuing it. But if it's a complicated case where we were going to spend all these hours writing up all this response and gathering all this evidence and interviewing, I mean, that wasn't worth it. And if somebody definitely had a decent case, and they were going to sue us anyway, then it usually wasn't worth it to mess with the EEOC. Why give somebody a preview of your case? Why risk putting out information that you may contradict later? I don't know. It just didn't seem like a great idea. So that's kind of how the apparatus is set up. You file an EEOC complaint, whether or not, no matter what the EEOC says, you can still sue. I want to get into, but I think I may wait till Thursday. No, I got time today. Yeah, because we'll have a lot to talk about Thursday. So there are, generally speaking, your employment discrimination cases are going to be split up into two types when it comes to evidence. All right. You're either going to have direct evidence of discrimination. Hey, Tom, we're firing you because you're old. Oh, you're about to have an operation? You have cancer? You're about to undergo chemotherapy treatment? You're fired. Direct evidence of discrimination. Okay? But most of the time, employers are not that stupid, although most people are idiots. This classroom accepted. Yeah, y'all remember one of my main rules of life. And so the evidence of discrimination is circumstantial. You can still sue for discrimination, but there is a different, it proceeds a little bit differently in the courtroom. So if I have direct evidence of discrimination, hey, you're fired because you're old, you're fired because you're getting sick, you're fired because you're a man, I'm the plaintiff, I'm going to tell the court, I have direct evidence of discrimination. Here it is. Your turn, defendant, employer, to justify it or to defend yourself however you want to do it. But if I have circumstantial evidence, it goes like this. I filed a lawsuit for age discrimination. I think that they fired me because I am over 40. Nobody told me that. I don't have anything in writing that says it's because you're old. But I do know that they hired a replacement for me who is significantly younger, had less experience. That makes me feel like, so another way of putting that is sometimes discrimination isn't direct, right? Maybe the CSU was like, we need some new blood in business law. We just need some new energy. We need, if we got somebody who was a little less experienced, we could pay them less. We could save some money, right? Those are all reasons, but they could be discriminatory indirectly. So if I think that I have indirect evidence of discrimination, then I file my lawsuit. I say why I think I've been discriminated against. And then the burden shifts to the employer to come up with a legitimate, non-discriminatory reason for the firing or the demotion or the whatever the adverse employment action was. Their reason that they give back could be he came to class wasted. He was habitually late. His student reviews were the worst we've ever seen. He doesn't get along with anybody. Those are legitimate, non-discriminatory reasons. Okay? So for circumstantial cases, I say that I think I was discriminated against. Then we turn to the employer. They get to say why I was, whatever action they took. Then I've got to show that their reason was BS. So normally, you go to court, you allege something, you got to prove your case, and the defendant they can put up whatever defense they want. This is a little bit different burden shifting. We go to court, I say I was discriminated against, they say no, you weren't, you were fired because of this. Then I've got to show that their reason is pretext, a false reason, a cover-up, a false justification, a BS reason for what they did. Not as easy to do, right? I mean, I'd rather have the email that says, let's get rid of that old joker. That's going to make my life a lot easier. Because circumstantial cases are harder to prove. Most cases are circumstantial. I mean, most employers are smart enough not to spell out or create some sort of smoking gun evidence. But that's sort of how those are set up. So I think I'm going to save that for Thursday. I had one more point I wanted to make today, which was that employment discrimination is not just for people who are fired. Employment discrimination could be in not getting hired, not getting a promotion, getting demoted, having some material aspect of your job changed. There are a bunch of different ways that could happen. I like to talk about firing because it's it's just an easy example. But it could also be not being fired, not being promoted, other ways. So on Thursday, I'm going to continue lecturing. Thursday, we'll switch it up a little bit this week. I want to do our cases on the back end. I want to finish lecturing. And you guys will have a quiz this week over the lectures for this week. It'll be due Monday. Next week, for those of you that came in late, next week I'm not going to be in town, so I want you to do your professional development next week. We have a grand total of one person so far in this class who's done their interview, so that's leaving a whole lot of y'all left to do your interviews. So next week will be a great time to do that. If you came in late, I did figure out that your interviews can be scheduled and done directly through the Career Center, either in person or on Handshake. They have lots of times and all for you to be able to do that. You do have a discussion question this week, which is has to do with family and medical leave around the world. It turns out that, remember how I told you earlier today that in America, family and medical leave is unpaid? We're one of the only countries in the world that has unpaid family and medical leave. Most other countries have some sort of, they have varying lengths, but you get paid for a certain amount of time. So your discussion question this week is to read a short article on that and give me your opinion on what you think is the correct or appropriate length of time that we should be paid or not for family and medical leave. So I'm interested in what your opinion is. Again, your opinion. Alexis, question.
I can answer this about it. I was gonna ask for on the Handshake app,
Yep.
which, is it the interview preparation appointment?
Interview prep appointment. Is that what you're looking for? Do y'all? There's a bunch of options. He's saying on Handshake.
So that sounds right.
I think that sounds right.
Make sure you do the tables before you go in and remember those questions and how to answer them.
I have one more grumpy old man thing to say before I let y'all go. I was reading, giving grades on some of y'all stuff that you've turned in over the break last week, and I was reading some of the personal codes of ethics, which is one of my favorite assignments. They're usually just, you do excellent jobs on those. There are a couple that are not personal. They are ChatGPT generated codes of ethics. It's easy to spot. If you did that, please redo it. You can email it to me. I will accept it. I will not penalize you. But if I keep going through these things and finding ChatGPT personal code of ethics, that's just an automatic 0. That's like the complete antithesis of what this assignment is intended to be. So that's my old man rant for today. Anybody have any questions? All right, I will see y'all Thursday.